Hey guys, it's Anthony Bandiera here, bringing the Roadside Chat. I'm broadcasting from Aurora, Illinois, teaching the entire department here. So thank you for having me. The question that we have here is, if an officer is in a parking lot, like at an apartment parking lot, and he goes up to the a car with tinted windows, and he uses his hands, right? He uses his hands to like look into the car, and he sees something in plain view. Would that be a search under the Fourth Amendment? It's probably not a very clear, definitive answer, but let's kind of walk through it. And first of all, why is the officer asking is because we know that from a case called Jones, that physically trespassing on a protected area, like a motor vehicle, that's protected by the Fourth Amendment, with the intent to gather information is a search under the Fourth Amendment. In Jones, they actually used a GPS tracker and followed the guy for about a month. Well, the Supreme Court found that the actual trespass was the issue, right? Whether or not there was a reasonable expectation of privacy was a different analysis. And so what cops are thinking of, well, if I'm touching this car, and I'm using that to gather information, could that be a search? And the answer, of course, is it may be, right? But let's walk through a couple cases. Number one is a court found in the Sixth Circuit that chalking tires for the purpose of parking enforcement was a search under the Fourth Amendment. So if that is a search, right, that case is called Saginaw versus Taylor, or Taylor versus Saginaw. If that was a search, then that could implicate, putting your hands on the window in order to see inside the car. That could indicate that it may be a search. We also know that poking a tire to see if there was something in the tire was considered a search under Jones in a case called U.S. versus Richmond out of the Fifth Circuit. However, on the flip side, we have a case called United States versus Polar. It's a 2023 case out of Connecticut. It's a federal district court out of Connecticut. So it's not a circuit level court. So it doesn't have precedential value. It's just persuasive to other courts. And they found that holding up a cell phone to a tinted window in order to see like inside the car, and just so if you're aware, if some of these new phones, right, that have like special cameras and so forth, but if you hold up your phone and you touch the window, even though it has tint, you can actually see through that window as if it had like X-ray vision. Now, going back to our question at hand, generally speaking, I think that the better argument is that this would be a search. I think that the case law is more in that favor when you look at Saginaw, when you look at Richmond. There was another case where the cops put their hand on the hood to see if the car was hot. I think that could be a search. And the next question, all right, are you touching a vehicle with the intent to gather information? The answer is yes. The next question is kind of like maybe what lawyers would say causation. Did putting the hands on the car and shielding the sun, did that actually cause you to see inside the vehicle, right? Was that the determining factor? If we can maybe argue that, hey, look, either way, if we got up to the car without touching it and we were seeing the same thing, we may have an argument that was not, it was not really a search, okay? I'm not sure that's going to work or not, but the point is that could also be something to throw in there. The Polar case, okay, where they said that holding a cell phone was not a search, they said basically that the defendant had no reasonable expectation of privacy against police officers' use of a camera function on a cell phone to look through heavily tinted vehicle windows and thus did not engage in a search in violation of the Fourth Amendment. Okay, they also said that sense-enhancing technology like a camera is in general public use. I got to tell you, undoubtedly, this judge got it wrong, okay? First of all, Jones does not really care about a reasonable expectation of privacy, right? Putting your hand on a hood for heat, does not invade a reasonable expectation of privacy. Poking a tire is not an expectation of privacy. And chalking tires for parking enforcement is not an expectation of privacy. These are trespass cases. They're totally different things. And this judge seems to me to be stuck in an era of before Jones and before the courts also analyzed trespass. So let's get that out of the way. Second, when you're putting the phone up to the car, are you touching it with the intent to get information? The answer is absolutely yes. This to me is absolutely a search. and the judge got it wrong. I don't teach this in my classes, and I'm not going to teach it until a higher court tells me that I'm wrong, because I think I'm confident that the judge got it wrong here, and so forth. Now, just because it's a search does not mean that you can't do it, right? Poking the tire, chalking the tire doesn't mean you can't do it. It just means that you have to have what I call CREW. CREW is an acronym that says if anytime you have a search or seizure, let's say we have a search, you need either consent, express or implied. You need a recognized exception. I want you to think motor vehicle exception, community caretaking, search, incident to arrest, all kinds of recognized exceptions. And if you don't have that, then look for your warrant. You have to have one of those three. Going back to our officer using his hands to look into the car, I personally would caution against it, even though I'm not positive it's actually a search under the facts. However, I caution against it unless you had a recognized exception. All right, my friends, that's taking my stab at that case. If you have any feedback on this, if you think I got it right, if you think I got it wrong, put it in the comments. Either way, let us know. And I hope that this video has helped you get it right every single time. Until next time, my friends, stay safe.